Chapter 9 of Tractate Kesubos continues on the laws of the marriage contract. The first Mishnah says, if somebody writes to his wife that he's relinquishing all of his rights to her property, he's still allowed to consume her produce and he still inherits from her if she dies first. However, if she decides to sell her property, it's a valid transaction. If he relinquished all of his rights to her produce, he can't eat her produce, but he still inherits from her. Some say he always can eat some of her produce unless he specifies he's relinquishing his rights to the produce of her produce infinitely. If he relinquished the rights to her property and produce, or produce of her produce during her life and after, he can't eat of her produce or inherit from her. Others say he does still inherit, as such a stipulation goes against the Torah, which makes it void. The Gemara says such a relinquishment can also be done orally. It brings proofs that a husband actually does have the ability to waive his rights to his wife's property or produce like this. Some say this is only effective during the initial stage of marriage, as during the later actual final completed stage of marriage, they actually equally share the property. Some hold that he actually has a greater share of the property, so there'd be a practical difference by a woman who's pending yibum. There are related points discussed by property ownership. There's more on this. It asks why he needs to say the produce from the produce until infinity to give up his wife's produce, and it's unresolved as to why you need each part of that phrase. There's further discussion, and it's ruled like the opinion that a husband can't relinquish his inheritance from his wife, but due to a different reason. It's debated as to what exactly this reason is. Then, according to this opinion, a husband inheriting from his wife is actually rabbinic. It's just that he says rabbinic laws are very strict, so they still can't be violated. And this is further discussed. New Mishnah, if somebody dies, leaving a wife, creditor, and heir, and he had a deposit or loan with others, some say it's given to the weakest of them, others say it's given to the heirs, as those don't require an oath to collect. If the dead man left detached produce, whoever gets it first gets it. If the wife or creditor took excess, more than what they're owed, some say it should be given to the weakest, others say to the heirs, as they don't require an oath to collect. The Gemara says the case has him leaving a loan and a deposit, as we need both. A loan is given to be spent, while a deposit is given to be held. This would create variation between the opinions if both weren't mentioned. The weakest of them, some say this means this would be the one with the weakest proof. Some say it means to give it to the woman for her marriage contract, so that way it'll function easier and women will marry more. There are similar points regarding the excess detached produce. The second opinion that says it goes to the heirs would say actually all of the produce does. He just mentioned excess here, as the first opinion did that also. It's debated where the produce goes, if it's kept in a recessed area near a public road. There are related points discussed and a few particular incidents regarding creditors of a deceased individual. These cases are discussed further, and there are further particular relevant incidents listed. Another point, if a man owes money to a creditor and for his wife's marriage contract, and he has land and money, the creditor gets the money and his wife gets land. If he only has land to give one, it's given to the creditor, as we're not concerned about women just not marrying anymore because of this one particular situation. There was a case where a man didn't have money to pay a creditor, but he did have land, and he was told to sell his land to pay the creditor, but that was only because he had lied and said he had no money, so the court decided to act stricter with him. According to the opinion that says repaying a creditor is the fulfillment of a mitzvah, it would be a positive commandment, which you're allowed to force somebody to do. There are further particularities by cases of a divorce document. New Mishnah, if one has his wife as a storekeeper or his business administrator, he can make her take an oath that she was honest with the business dealings if he wants. Some say he can even make her swear he didn't take his stuff outside of work. The Gemara says, according to this latter opinion, it's debated based on if the husband can be so imposing. Even if she's also sworn by the business, according to this opinion, the oath outside of business can be made even before the oath within business. New Mishnah, if a husband writes to his wife that he won't make her vow or oaths, he can't do that with his wife, but he can with her heirs and successors. If he wrote that he won't vow or oath with her or her heirs and successors, he can't impose an oath on any of them, although his heirs can. If he wrote such an oath, and also specified that his heirs can't impose such an oath, he and his heirs can't impose oaths on her or her heirs or successors. However, if the husband died and the wife went back to being the administrator of her husband's business, his heirs can make her take an oath about future events, but not about past ones. There's debate about what type of oath is exactly being referred to. Some say it's over the administrative position, others say it's over her trying to impair her marriage contract. This is for the discuss. It goes through various different phraseology of the husband to free his wife from oaths, as to which are considered to be legally effective and which are not, and for what. It said we hold out the opinion that he and his heirs cannot impose oaths, whether he wrote without oath, clean of oath, without vow, clean of vow, or my possessions or these possessions. New Mishnah, if a woman impairs her Kesuba marriage contract, admitting it was partially paid, or there's one witness that her marriage contract was paid, she must take an oath to collect the remainder. She'd also need an oath to collect her marriage contract from the property of orphans, from encumbered property, or if she's doing this not in her husband's presence. A woman impairing her marriage contract, for instance, it was for 1,000 zuz, and the husband said, I already paid it, and she says, no, you only paid 100 zuz. She collects the remainder with an oath. The case of a single witness is if the marriage contract was for 1,000 zuz, her husband says he paid it, she says, no, you didn't, and a single witness says, yes, he did. She'd need an oath to collect the payment. Collecting her money from encumbered property is where the husband sold his property and she's collecting her contract from the purchasers. It must be done with an oath. Collecting from orphans' property is where the husband died and left his property to orphans. She's collecting from them with an oath. Him not being in her presence is where he's overseas, so she, again, must collect with an oath. Others say, whenever she claims her Kesuba contract, the heirs can impose an oath on her, and if she doesn't, they cannot, and this will be explained. The Gemara suggests that by the impaired contract, it's a biblical oath, as she's admitted to part of the claim. This is rejected, as it's only biblical if she's not paying, and here she's taking payment, and also it's not biblical to swear on the denial of land lien. Rather, it's said that this is a rabbinic oath to make her pay attention when she's paid. It's unresolved if we assume it's true if the woman impaired her contract while there were witnesses there. It's also unresolved what if the impaired amounts are in very small numbers, such as under a peruta currency. There's no oath imposed on a woman who devalues her currency, and there's a presumption of trust between the husband and wife, as the original contract is now admitted to be void. There's the same debate if the oath by a single witness is biblical or rabbinic. It's said to be rabbinic, and it's done to put the husband's mind at ease. If the husband wants, he can make the woman take a biblical oath by re-giving the woman the contract payment before the first witness and the second one, and then establish the original payment as a loan, thereby forcing her to now take a biblical oath. This only works if he tells the witness what's going on beforehand, so she can't claim there were just two marriage contracts. There are related cases discussed. It also debates exactly which cases the last opinion was referring to, which was on the earlier Mishnah back on 86b and others. New Mishnah, if a woman brought out a divorce document but no Kesuba marriage contract, she can still collect her Kesuba. If she had just the Kesuba but no divorce document, meaning she says she lost the divorce document and the husband says that he had paid it and lost his receipt, or similarly, if a creditor brings a loan document but no document authorizing the court to collect his debts, neither the woman nor this creditor can collect their payments. If it's a dangerous time, it's that they can collect such payments without those other typically necessary documents. The Gemara further discusses these points, which are qualified further at length. New Mishnah, if a woman produces two divorce documents and two Kesubos marriage contracts, or two Kesubos and one divorce document, or two divorce documents and one Kesuba, or a Kesuba, a divorce document, and proof of her husband's death, she gets one Kesuba payment, as if somebody divorces and remarries his wife, he does so based on the first Kesuba without rewriting one. The Gemara discusses this further. New Mishnah, if a minor was married off by his father, which is not legally allowed, however the marriage does go into effect when this person becomes of age. The Kesuba that was written while he was a minor stays in effect. This also applies by a convert who converted with his wife. Their marriage contract stays in place from before the conversion. The Gemara debates if this contract is just the base minimum of 200 zuz, or if it also includes any extra sums added. It said no, it only refers to the principal minimum of the Kesuba. And that's the end of Chapter 9. Chapter 10 of Tractate Kesubos covers additional laws of the marriage contract. The Mishnah says if somebody was married to two wives and he died, and there's not enough money to pay for both Kesubos, the marriage contracts, the first wife has priority for payment, and the heirs of the first wife have priority over the heirs of the second wife. If he married the first wife, she died, he remarried, and then he died, the second wife and her heirs have priority over the heirs of the first wife. The Gemara suggests, based on the wording, that if the second wife takes her contract first, she would be allowed to keep it, which would mean that if a person had two creditors he owed money to, and the second creditor comes first, he can collect his money, seemingly. This is rejected based on similar uses of this wording. Some say the entire argument happened in the inverse, actually. Further, from the Mishnah, it can be learned that that if a man's two wives die, one during his life and one after, the heirs of the first wife have priority to the marriage contract for the male children, and there's no concern of this causing argument. Also, we can learn that a Kesuba can become surplus to another Kesuba. We can also learn that the Kesuba towards sons cannot be collected from encumbered property. The logic of these conclusions is described, and the validity of these statements are debated from several sources. It's further debated and ruled that if a man's two wives die, one before his death and one after, the heirs of the first wife have rights to the Kesuba for sons. Also, it's ruled that a Kesuba can become surplus for a counterpart Kesuba. It explains the necessity for both of these statements according to various opinions. New Mishnah, if somebody married two wives and both of them died, and then he died and there's only enough money to pay for the Kesubos, the money is split equally between them, and if there's any surplus money, the Kesubos are paid as written and the surplus is split between them. The property is appraised by a court, so no party can inflate the value. If there are prospective assets in the estate, they are not treated as owned. Some say even movable property is not counted. The excess money split only occurs if there's enough actual property to pay the Kesubos in full and a dinner more. The Gemara discusses these points. There are a number of relevant cases cited and discussed in regards to property collection and similar, which are further discussed. There are a few additional rulings mentioned, such as if a person sold a field to another with a guarantee and the creditor comes to collect money from the first person, so he goes to the field he sold to the second man. The first man can argue on behalf of the second person to not take the field, as he is going to have that amount of money taken away from him by the second guy. Some say this applies even if there's no guarantee, as the first person is considered to be a concerned party, as he doesn't want the second man to get upset at him. Additionally, some rule that if one man sold a second man a field without a guarantee, and then protesters claimed it was never the first guy's field to sell, so long as the second guy hasn't made a proprietary act to claim the field, he can retract from it without paying. A proprietary act is like walking along the border of the field. Some say this applies even if a guarantee was made. New Mishnah, if somebody marries 3 wives and then died, and the Kesubos were 100, 200, and 300 zos respectively, and he only has 100 zos, it's divided equally. If he has 200 zos, the first one takes 50, and the second and third take 75 each. If there were 300 zos, the first takes 50, the second takes 100, and the third takes 150. The system also applies if people deposited money in a fund, and they had a loss or a profit, it's divided like above. The Gemara explains by the middle case, the first woman got 50 zos, as the second woman removed herself from the claim to the first 100 zos, so it's being split between the first and third woman. However, the second woman still gets her amount because she didn't totally remove herself from her necessary payment. Similarly, by the third case, the third wife removed herself from the claim to the first 100 zos. Others suggest these cases deal with 2 different seizures of property by the wives, which is described. This is further discussed. New Mishnah, if somebody married 4 wives and died, the priority goes in order of marriage, and each must swear to the next that they haven't yet been paid, although the fourth does not need to do this. Others say the fourth actually must collect with an oath. If the Kesubos were all written on the same day, it goes by order still of who was written first, by the hour, which was recorded on these documents in Jerusalem. If they were all written within the same hour, and there's under 100 zos in the estate, it's divided equally. The logic of the dispute is debated along with related points. These are further discussed along with further cases of conflicting deeds which have the same date. New Mishnah, if somebody married 2 wives, sold his field, and the first wife wrote to the field buyer that she has no claim over this field. When the husband dies, the second wife can collect the field from the buyer, and the first wife can take it from the second, and the buyer can take it from the first, and they can just keep on going around in circles until they reach a compromise. This also applies by a creditor and a wife who is her husband's creditor. The Gemara says the case is where the buyer did an act of acquisition with the field with the wife, so when the woman rejected the field, that has legal validity. Others disagree, and some suggest this is dealing with a divorced woman to make the case work like everybody. There's further debate on this. It's discussed and it's ruled that if free property becomes ruined, a creditor can collect from encumbered property, and there's further discussion on these points. And that's the end of chapter 10.